Good afternoon, everyone. I'm James Sanders. I'm one of the employment law partners here at MST. I'm going to finish the first part of this seminar today talking about employment law issues that you need to be looking at for the remainder of 2026 and into 2027. There are 5 areas that I believe you need to be paying particular attention to for the remainder of this year. The first you should already be up to date with, payday super. That came in on the 1st of July. You were required to start paying superannuation every pay cycle, not every quarter. This opens you up to more breaches if you don't do it in time, which leads to further penalties. So it needs to be focused on. The second is that every state and territory now has statutory right and obligations for psychosocial hazards. This means that you now have to focus on the mental health of your employees as much as you do on their physical health. Everyone is attuned to making sure there's no tripping hazards, but not as many people are attuned to what is going on inside their employees' heads in terms of workload and risks in the workplace. Third, the ever-present worker classification. Employees and contractors alike are looking for more money. It's tough out there at the moment. And so they want to stay as contractors or casuals for a longer period of time. But that opens up risk for you as the employer for misclassification and leading to underpayments or non-payment of superannuation. But with that said, I think there are 2 very key areas you need to be thinking about. The first is flexible work arrangements and more specifically, working from home. Since the introduction of the Fair Work Act, employees have always, or certain employees have had the right to request an ability to work from home. It wasn't until 2023 that this was changed to provide employees an ability to appeal any decision of the employer. Prior to that, employers were free to reject the request on any grounds they saw fit with no fear of reprisal. Now, you as an employer need to go through a true process of ensuring that employees, or when an employee makes a request, you've considered the refusal before making the decision. And whilst we've had some decisions go both ways from the Fair Work Commission, now that they are making their way through the Commission, there is a very clear trend that the Commission is providing to us. And that is, if you as the employer have not truly considered the employee's request, and you haven't considered how the refusal will affect the employee or what the effect will have on other employees or your business, the Commission is going to find in favour of the employee, including allowing them to work from home 5 days per week, even if the reason they need to work from home is that they've decided to move 2 hours out of town and away from the office. However, if you as a business have genuinely attempted to resolve the issue or the request with the employee before refusing by making alternative options available to them, identifying to them the reasons why requested flexibility isn't going to work, the Fair Work Commission is making very favourable decisions for employers. And so it comes down to the important fact of what have you considered before you make your decision. This is only going to be exacerbated in Victoria. We've currently got the draft work from home legislation before the Parliament. We expect that to be in place before the start date for large employers of 1 September. And you will now have to make a decision, not only employees requesting under the Fair Work Act, but your Victorian employees making a request or accessing their right to work from home 2 days a week. So it is more important than ever to ensure that to defend any of these claims, if you decide to refuse and they are appealed, that you have a paper trail. Make sure you've gone through the process correctly and documented exactly what you've done to make sure you give your best chance of asking employees to, or requiring employees to return or stay at the workplace. Essentially, if it's not in writing, those conversations never happened. The second key issue you need to be thinking about is an increased chance of litigation. The the president of the Fair Work Commission presented at a CPD earlier this year, where he indicated that we were expecting 55,000 applications when questioning an employee's termination in the financial year of 25-26. This was an increase of 25% on the year before, which itself was a record year. The Fair Work Commission's own analysis has also showed that in the year from February 24 to February 25, about 85% of employees question their termination of employment at the Fair Work Commission. Again, this was up from 76% the year prior, and they're predicting in this financial year that number is going to be over 90%. That's 9 out of 10 employees taking an application to the Fair Work Commission to question whether or not their determination was valid. And we're seeing it more and more, and this is a common theme we've heard from the others today. AI is in the background. Employees are being dismissed from employment, going home, jumping on their AI generator of choice, and within minutes producing a fully fledged application to the Fair Work Commission. And within an hour of their dismissal, they've lodged an application in the Commission. What this means for you is that you need to document your processes much more strictly. These employees are going to mediations with an inflated view of the prospects of their case, an inflated view of what their case is worth. The more documentation you can have that you can provide to the Commission, that the mediator can rely upon to talk to the employee in that mediation and convince them to come down off that ledge, the better chance you have of a favourable outcome early before having to go through the process of either defending it to a hearing at the Commission or a hearing at the courts. That is, of course, going to save you time, effort, and money. The secondary issue arising out of this increased litigation is that we are seeing a significant delay in the Fair Work Commission. What used to be a couple of weeks or a couple of days to receive an application is extending into 6 to 8 weeks. So you've dismissed an employee, they filed, but you're not receiving it for 8 weeks. And then you have to deal with it. And that delay has a flow-on effect to the mediation date, to the issuing of the certificate, and ultimately the hearing. General protections claims at the moment are taking 2 to 3 years to be heard at the court. And you'll be dealing with that in 3 years' time when you dismissed an employee. Slide, please, Dina. So the key point here is you need to document and show your workings more than ever as an employer. Of course, most employers aren't out there intending to break the law, but businesses change, the laws change, and you need to keep up with them to ensure that the reality is actually what is being projected to your employees and what they're seeing. Take worker classification, which I've already mentioned. Businesses, you're going to say that person's a contractor, and they may have started that way, but you need to ask yourself the question, what does a relationship actually look like? Do they operate their own business? Do they work for other clients? Who controls their hours and how is the work performed? The same applies to psychosocial hazards. Just saying we've got a policy to protect our employees is step one. And it's a great step one. You'll be beating half the employers out there if you have one. But can you actually show that you've identified the risks, you've consulted with staff, and you've responded to concerns, and then you've taken those practical steps to mitigate the risks in the workplace? Again, documentation is going to be key to defending any claims. Slide, please, Dina. So what should you be looking at now? I've put a range on that slide, a long list of things you need to be looking at. And of course, there's no order of importance. You can't look at them all at once. It would be impossible to do so. But as an example, you could start with your performance management and termination process. Make sure your managers know what the process is. Make sure they know what to document. Have a look at your contractor and casual agreements. Look beyond the label. Are they actually what you say they are or what you think they are? Or do we need to review how they're actually operating to make sure we've got their classification right? And then have a look at your policies. Not only should policies be updated, but employees have to be trained on them. Ask yourself after today's presentation, when was the last time I ran a sexual harassment or a bullying training session in my workplace? It's great to have a policy, but you have to do the training as well, and you have to document. Next slide, please, Dina. So that's my presentation, or my part of the presentation. So what have we seen from the others today? We've had Rainier asking if your commercial contracts and structures still reflect your business and how it operates. Louise has asked if you own and control the assets you rely upon. Evelyn has asked to check your leases to support your next move. Do they do what the business needs? Mark's asked if you've got any unresolved issues that are reducing your options moving forward. And I've emphasized the need for your workforce arrangements to keep pace with the way people are now working. You, of course, do not need to review everything at once, but you should identify where your documents, systems, or relationships may no longer match reality. The important point is not to wait until a sale, a dispute, or some other major event forces you to review your documents. Do it proactively and do it early. I'll now hand back to Rainier, who's going to start the fun part of this presentation, which is the case study, which will show how all 5 of our areas of law can sometimes end up being involved in one matter. Thanks, Rainier.
You're on mute, Rainier.
Sorry, couldn't get a mouse. All right, so yes.